Good afternoon to everybody. Can you hear me?
Yes.
Okay, that's fine. Because every now and then I try to change the setting, the location. I'll try to do a next lesson from Capri or some other rather fancy location. Now, what we're going to do today and the next lessons is try to go into a different field which we have not examined, or rather we have examined only in a limited way in our first lessons, and that is the field of criminal law and procedure, in the sense that we have to try to understand under what aspects legal systems are different when we look into the criminal law and procedure aspects. This is somehow, I feel, very important because we see that the criminal system, the criminal law system, is somehow the ultimate door of a legal system, in the sense that the legal system needs some kind of limit to all kind of human activities, and beyond those activities there is a criminal sanction. And if certain activities are not done according to what the law prescribes, then there will be some kind of criminal sanction. So this is very delicate when we look in democratic systems, because on the one hand we are very much focused on freedoms and on liberties, but at the same time we want to know what are the limits to these freedoms and these liberties. So just to show that this is the outmost frontier of a legal system is represented by criminal law, and it presents very complex issues which are not only legal, but as we shall see, they are also ethical, moral, and of various non-strictly legal nature. So we will try to focus on this. Now, just let me, sorry, I must open the slides. Sorry, just 1 second, please. No, I can't minimize this. Okay, then let me go on the slides. Yes, okay, 1 second. Sorry. Okay, just let me go back here, and okay, here we are. Can you see the slides now? Sorry, can you see the slides now?
Yes.
Okay, then just let's go through a few basic principles, in the sense that criminal law has always existed, and as expression of the power of the state, in the sense that when a state is organized, it has also, from its beginning, it has some kind of criminal system. Now, we are now in the 21st century. It is very clear what we mean by criminal law. We shall see that this is not, it is a slow development, and that what we now call criminal law not necessarily is considered as such 3,000 years ago. Just to point out, we will use a modern term for something that has always existed, maybe under a different notion. Let's say harsh sanctions. Why is this? Because clearly in ancient times, obviously, the ways through which one could coerce social behavior, individual and social behavior, were pretty strong and pretty rough, and clearly criminal sanctions, what we would now call criminal sanctions, were the main form of instrument through which the state managed to obtain obedience to the laws. What is the first point? That although we find criminal sanctions, what we now call criminal sanctions, in very ancient states, the turning point is when at a certain point these rules are set in writing, and therefore we have evidence of these rules. I'd just like to point out this example, which is a very good example, which dates back to the 18th century before Christ. Just let me put this in a more readable form. Let's see if I can make this, put this in. No, it doesn't, can't read this. Let's see if we can. I want to make you read this. No, obviously not. I can't manage. Anyhow, we have this Hammurabi Code. It's called Hammurabi Code because it was discovered in the archaeological excavations around the beginning of the 20th century. And as that was a time in which codes were the main, seen as the main container of a legal system, well, this was called Hammurabi. Hammurabi was a king of Babylon, and we find this very long text, and we have recovered more or less 250 provisions, legal provisions, which are set in very clear form. They're not sort of discursive. They're very clear. They're very precise, and more or less half of them are devoted to what we would call criminal law and criminal sanctions. Death penalty, bodily mutilation, exile. So this is why we describe these as criminal law provisions. And because the other half are instead in private law provisions, are very interesting. I mean, when you study the history of private law, at least in the Western area, we find all the principles of, for example, of enforcement of contracts, wills, family relations, and typically extra-contractual liability. So this is very, it's it's a very important text from an historical and anthropological text. We find there in Hammurabi's code notion of eye for eye. So if someone hurts someone else and this person loses his sight, then the sanction will be removing the sight from the offender. So this gives you the idea of how ancient our roots are in this criminal system. Anyhow, on the slides you can see the link with the text if you really are interested in these historical facts. You can find the whole text, the Hammurabi Code, the English translation. Obviously, there are French and Italian translations too. But at the same time, we must not forget that in the development of this branch of the law, it is very strongly related to both magic and religion. And I would like to recall this to our Italian students who have recently studied Roman law, because in the 12 tables, which are the sort of the first expression of written law of Roman law, well, we find a very clearly series of connections between the formulas which were used and magic formulas. So it always has been to do, there's always been anthropologically in our societies, there's been always a very strong relation between criminal law, magic, somehow procedures, formulas, and obviously religion. And this goes a very way along the times, because we started away in Babylon, and apparently Babylon was very sort of secular approach, because it does not much reference to divinities. But if we go well into the Middle Ages, this is well into after the Middle Ages, the 15th and 16th century after Christ in Europe, we still find the so-called trial by ordeal. And the notion of trial by ordeal is the fact that somehow it is God's judgment. So if you manage to pass this ordeal, typically walking on hot coal, on wooden, passing through the flames and so on, and if you pass through this unscathed, you are innocent, otherwise you will be condemned. So this idea that somehow divinity influences the criminal judgment, it goes well into our societies. And this is important because it goes well into the 15th, 16th, 17th century in Europe, and this takes a lot of time before we manage to get out of this idea that somehow criminal law and criminal procedures are somehow of a divine nature, and are somehow imposed by the divinity, by God, and that is some kind of sanction that God is sending against those who have violated its law. And again, following this line, I would just like to remind you that in many of our Western countries, well until the 18th century, this nexus between religion and law, violation, a sin becomes a crime. And so these two aspects are put together. We shall see how at a certain point we manage very slowly and with difficulty to separate very clearly what is a sin, that is something that is a violation of religious rules, and what is a crime. I'm pointing this out because this separation does not exist in all parts of the world. If we look at Islamic Sharia, which is the sort of the body of rules, of religious rules, which have, from our Western point of view, a legal content, well, we see that clearly violation of certain religious rules bring some kind of sanctions, which are which we would qualify as criminal sanctions. Typically, the fact that someone is converted to a different religion, apostasy, well, that is sanctioned through death, what we would call death penalty, just to show that this separation between a religion and crime, what is a sin and what is a crime, is a very long process which we in the Western legal system have managed to overcome only around the 19th century. So I just like to point this out to you. So this is somehow is clear, these roots, and why criminal law is such an important aspect. Also, when we look at legal anthropology, when we try to understand what are the reasons behind certain legal provisions and where they come from, and we find they have very, very ancient millenary reasons. Now, let's see if, yes. So let's go back to the role that criminal law and procedure, then I will focus on this aspect and why, criminal law and procedure, and try to focus very clearly on that, on this aspect, law and procedure. First point I was making was that criminal law is seen as the expression of state authority, in the sense what we would call law and order. So in order to keep a society in order, you need laws, and these laws are criminal laws, because those who commit violations of the law will be very heavily sanctioned. So this is just an important aspect. Clearly, what law and order was meant in the times of Babylon, what it is meant today, is different, but the whole idea that criminal law has the role of keeping an orderly society. Society is not orderly if there's not some kind of criminal, that they're not criminal sanctions. Second element, which is very important because it shows the role that criminal law has in the development of society. Not only we want an orderly society, but this orderly society is not only the fact that citizens, subjects, do follow the law and are comply with the law, but also the fact that you want to eliminate private vengeance. So if someone suffers some kind of tort, someone suffers an injury, the punishment is in the hands of the state. So the idea that only the state has the right to impose sanctions. Now again, this is something that takes a lot of time before it develops. We know this mostly because we've seen lots of films, especially Hollywood westerns of the Wild West, but not only in the Wild West, the idea of lynching, that at a certain point someone who has committed a crime or who's supposed to have committed a crime, suspected of having committed a crime, is killed by the mob. So, I mean, this is sort of private and private and collective vengeance over a person. There's no state intervention. Now, we see this as something completely contrary to our view of the law, but it shows how long it takes before we manage to move from a very primitive and I would say even savage forms of administration of justice to very much more complex forms of judicial systems and judicial sanctions. Just to point out that this idea that the state wants to keep order, but at the same time the state is an evolution of society, of organized society, and only the state has the monopoly, can impose and enforce sanctions, criminal sanctions. So just to keep in mind this, because this is, I mean, when you will study, if you haven't already studied criminal law, you will see the issue of what point somehow sanctions, which we would consider as criminal sanctions, can be somehow imposed by private entities. Now, these very ancient roots of criminal law are important for us as lawyers, because we see that criminal law, together with private law, is the heart of the law faculty curriculum. When Bologna University is founded in 1088, that is practically 10 centuries ago, I mean, had messages, but the core and criminal. Just to keep in mind that what does this mean? That it has always been an academic topic, and therefore, especially in the European continent, around criminal law, there's been an organization of the system. You had to teach students what criminal law was, and therefore you had to develop a theory of criminal law. This is very important because it's the relationship that exists between universities and the development of a legal system. We shall see this when at a certain point, but only at the end of the conclusion, we shall see the role of universities in shaping a legal system. To what extent university teaching, not what you are studying today is the result of centuries of what has been studied in universities before. So just to point out that we have such a very strong attention to criminal law because it has been for centuries a main central topic of our university law school curricula. And obviously this means that criminal law, as it is a practical subject, it creates criminal lawyers. So therefore we find that there are, as the criminal law has to be enforced, then we find these lawyers who are specialized in criminal law and are there mostly to defend the people who are accused. So this is very important. So we see this, the state has this monopoly over criminal law, and at the same time lawyers come in. Well, some may become judges, but most of them are, many of them are there to defend the rights of the people accused. So this creates a dialectic, a very dialectic relationship between a branch of the law and its practical enforcement. So just to point out that this shows how it develops, how criminal law develops, because it is not only, it's not only the state that decides that certain behaviors are antisocial, they are against the king and therefore must be sanctioned, but we find a series of individuals, lawyers, who are there who somehow try to mitigate the role of the state and therefore to get their client acquitted from the accusation. So this is a very interesting aspect of how the law is developed in this field. So there's a state on one side, there's which the state that wants to sanction certain behaviors, and then the lawyers who mostly, at least in continental Europe, have come out from the from law faculties, who are there to defend the rights and the reasons of the people, the persons who are being accused. Second element that I would like to point out, which is very important, because then at a certain point we shall see a bifurcation of the Western legal tradition in this field, is the fact that to enforce criminal law, you need a trial. Now, this is interesting. So, while private law exists without the need of courts, I mean, if there is a contract which two people agree on something, let's imagine a sale. I will pay you 1 coin for your horse. Well, if the parties comply with their contract and that contract is fulfilled, I give the coin, I receive the horse. Well, there's no need of going to court for that. So there's social and economic practice puts private law, makes it function by itself. Then we shall see that there are some pathological aspects by which the parties will have to resort to some kind of judicial procedure. But in the great majority of cases, private law works through social behavior. Members of the society agree on what they are doing and will fulfill without many problems what they have agreed to fulfill or what they feel is their obligation. Criminal law exists only if at a certain point it goes to court, because if I go and steal in a house and I'm never discovered, well, yes, surely there were people who have been robbed, who've been stolen from their house, will complain, will go to the police and complain, but they will be, I am not discovered, and therefore there will be no accusation, no trial, no judicial decision in this field. So criminal law exists if there is a trial that somehow verifies if that accusation is substantiated and if the accused is innocent or therefore must be acquitted, or is guilty and therefore must be sentenced. So just to point out that this is very important, because this means that we cannot look at criminal law if we do not look at the trial, where the place where this crime committed is verified, and therefore we need a court. Generally, we relate this to the fact that there's a judge, and this is a very important aspect in the development of criminal law and therefore procedures. So just to point out that we cannot, just to point out why criminal law is so particular in its structure. We look at private law, but even if we look at administrative law, if there's an administrative regulation that says that you must do something, let's say driving license, which is a typical administrative procedure, well, people just go to a driving school, they learn, they take their driving lessons, they pass the exam, and then have a driving license. Well, everything works normally. There's no, substantially, there's no contrast, except when maybe someone is driving under the influence of alcohol, and therefore his or her driving license is withdrawn. But that is something that may happen eventually. Criminal law needs to be substantiated, not to be only in the books, in something which is written in some piece of paper, or as at the times of Hammurabi, in a clay tablet. It needs a trial, it needs a court, and it needs procedures. So just to put these various aspects together. And so at this point, as criminal law exists only if there is the state intervenes and enforces this law, we have one of the main dialectic positions in this relationship. On the one hand, we have the state that wants to keep order in the society, and on the other hand, we have individuals who try to avoid and to challenge what they feel are abuses of power. As criminal law is a typical expression of power of the state, individuals somehow resent this and try to react against this eventual abuses of power. Now, this is typically Western. We do not find it in many other societies. So just to point out that then criminal law is all the time, there's a conflict between the state that wants to impose order and individuals that somehow want more freedom. And here we have sort of basic principle. Let's move to modern times. Look, we've already seen the Magna Chrta as the sort of the roots of fundamental rights in Europe. If we look at paragraph 39 of the Magna Chrta, 1215, so well, 8 centuries ago. So I mean, it's something that shows how evolved that society was in England in the early 13th century. This is obviously, the text is in modern English, not in the original text. No free man shall be seized or imprisoned or stripped of his rights or possessions, or outlawed or exiled or deprived of his standing in any way, nor will we proceed with force against him or send others to do so, except with the lawful judgment of his equals or by the law of the land. So this gives you the idea that it is the Magna Chrta is there to protect freedoms and to limit abuses of power of the in that time the king, and obviously of his administration. So just to point out that this shows us how important criminal law is when we look at the relationship between the state and individuals. Now, let's move just slightly more . Sorry, I don't know why, but let's see if I can manage to move here. Sorry, I don't know why, but the slide is not changing. Yes, here we are. And if we move still on, because we have sort of very important role that we find in England and English law in the development of some basic ideas in criminal law, we find this Habeas Corpus Act 1689. 1689 is still in force. That this piece of legislation, which you see is at the same time as that of the Bill of Rights of 1689, so it is dates to that same period, it goes together. The Habeas Corpus Act, which is a piece of legislation which is still in force in Great Britain, the sheriff, meaning by the sheriff, that means we would translate this today, the police. Anyhow, some authority which has the power to arrest someone within 3 days after service of habeas corpus. So when it has received an habeas corpus, with the exception of treason and felony, and it's under the regulations here I mentioned, to bring up the body means the accused person before the court, to which the writ is returnable in certified true causes of imprisonment. Now, this is obviously written in 17th century English. The whole idea is that if someone is arrested, then the authority that arrests must go to the court, and the court will issue a writ of habeas corpus and say, you must, within 3 days, physically, this person must be brought in front of the judge. You can't keep this person in jail, segregated. You must, that is why it's habeas corpus. The idea that the body, the person himself or herself, must be presented in front of the judge. So if there's been, for example, the person has been tortured or has been beaten up, so the person can say what has happened. So this is also to avoid physical violations of the physical integrity of the bodily integrity of the person who's been arrested. Must be brought in front of the court. So a judge decides if that arrest is legal or not illegal, and certify the true causes of imprisonment. This means stating the reasons, the accusations. So you must know what the accusations are. Typically, generally one was arrested and one didn't know why. If you read, some of you have read Kafka's Trial, well, Mr. K was arrested, but he never knew why he was arrested. He never got to know why he was arrested. Someone had some bone of contention against him, but he never got to know why he was arrested. So the whole idea is that you should not only have brought in front of a court, but you should also be able to know what the accusation is. And I will send you back to the 4th, 5th, and 6th Amendment to the U.S. Constitution, or slides, first slides that we saw. So these are sort of the basic history of criminal law, how it develops, and then now we will move on to a new page, and this completely new page, which is in the 18th century. But before we move to this new page, I just wanted to ask, first of all, let's stop here. Trial or ordeal, yes. Margherita de Masi to everyone. Yes, I just wanted to. Now, trial by ordeal, let's see if I can manage to find some kind of nice image. Just 1 second, I'll show you. If my system opens. No, obviously the internet does not open. The whole idea is that instead of going from, in the Middle Ages, the ultimate entity that was in charge of administering the law was the king. Why the king? Because the king was received his power from the divinity, from God, and therefore he was administering justice in the name of the God Almighty. So this is the basic idea. Now, sometimes the king gave gave the case to his judges, to his courts. Sometimes instead, this decision was somehow said, well, we shall leave this to the Almighty. The Almighty will decide if someone is or is not guilty. And that is the trial by ordeal. I'm sorry, but let's see if I finally manage to access my... You will forgive me, but sometimes when you change computer, it's not always. Yes. Now, when finally Google will open, I'll show you some typical images of trial by ordeal. And let me bring you to, I'll share. Here we are. Can you see the images?
No.
No?
No.
Okay, then let me go.
Yes, it's just loaded.
Okay, now yes.
Okay. Now, what happens? You see various examples. It's or you have to walk on, let's see if we see typical examples. Very good example where you have to walk on burning coal, or you were put inside the river, and if you managed to come out without drowning, you were innocent. Or there was a duel. Also, a duel was a typical example of trial by ordeal. Or here you see hot water ordeal. So here, if you have, just let me go here, you put your hand in the cauldron, and therefore you somehow, if you did not burn yourself, well, you were innocent, or instead, if you did, you were obviously you were guilty. So just to, let's see if I find some nice other image of trial by ordeal. But anyhow, the whole one second, just let me stop the share. Completely superstitious. You could try to address this idea of this somehow some religious aspect. There's nothing to do with religion. It's just the idea. It is really superstition, going back to the magic roots of criminal law and thinking that somehow there's some kind of magic that is going to decide who is guilty or who is innocent. Clearly, the fact that you could survive the ordeal, generally nobody survived the ordeal, was, and if you survived it, you were innocent. Well, to our modern minds, makes absolutely no sense. But this was quite common, and if we look at, we read even in Umberto Eco's Name of the Rose, we find a series of examples of trial by ordeal in those times. So just to point out that this was quite common and showed how much in the Middle Ages the idea that the administration of the law is somehow related, well, we would call it magical superstition. For them, those times it was religion, but it had nothing to do with true religion, and we do not find any somehow indication in the sort of at least in the gospel that this idea that sort of that some magic intervention of the Almighty would decide who is right and who is wrong. Habeas corpus. Shabadi is asking, did the Habeas Corpus Act give the possibility for one who was being imprisoned to defend himself? Yes, obviously. The whole idea is, and if you look at the Sixth Amendment, Fifth and Sixth Amendment of the U.S. Constitution, it's very clearly stated. You have the right. I'll go back to them. I'll go back to the slide. You have the right, fundamental right, to know, to be brought in front of the court and to know exactly what the accusations are and to able to defend yourself through a lawyer. So if just 1 second, if you give me 1 second, I'll go back to the slides. Let's see if these. There's Fourth Amendment. Let me go on to the Fifth Amendment. And the Sixth Amendment. In all criminal prosecutions, so can you see this? Sorry. Can you see the slide?
No.
No.
Sorry, let me share the, sorry. Share screen. Okay. You should see it now. In all criminal prosecutions, the accused shall enjoy the right to a speedy public trial by an impartial jury of the state where the crime has been committed, and shall be previously ascertained by law and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, and to have compulsory process for obtaining witnesses in favor, and to have the assistance of counsel for his defense. Now, this obviously is the end of the 18th century, but this was already clear in the Habeas Corpus Act of 1689 that the sheriff, when he brought the accused person in front of the court, had to produce also not the accusation, the evidence, and at the same time, the accused person could have the assistance of a lawyer. So this is essential. We see how these aspects, these procedural aspects, I will enter more in detail of these procedural aspects of criminal trial are important, but they were already there well in the 17th century. In the Habeas Corpus Act, it was very clear that you had to know what the accusation was, what was the evidence against you, and obviously to have the assistance of a lawyer, of a barrister that could defend the person in front of the court. Because it's important, we shall see it further on in another model, we see, especially in the English system, the courts were very much independent from the crown, and therefore and the kind of relationship that there was between lawyers and the court is particular relationship in the English system. So surely, so bringing the accused person in front of the court was an essential aspect of English criminal procedure in those times and also in contemporary times. Now, just 1 second, just let me see. Sorry, I'm just lost. I don't know why I don't. One second. No, let's go back to, let's see if I manage to get back to my, sorry, I'm getting myself lost in the, yes, here we are. Now, let's see, okay. Let's get back to the slides. So just keep in mind what the Sixth Amendment to the US Constitution says and expresses it very clearly, the idea of what we mean by habeas corpus. It was clear in the end of the 17th century England, and it's clarified in a very precise way in the Sixth Amendment to the US Constitution. Now let's return to sorry, 1 second, let me go back. Now, we've seen some sort of aspects, historical aspects, going from Hammurabi to sort of 1750 before Christ to 1689 after Christ. So we spanned over 3,000, more than 3,000 years. Now, I just would like to go to one turning point. There are some turning points in legal history. We've seen some, the American Constitution, the French Declaration of Rights of Citizens and Men, the Magna Chrta. We've seen various turning points in the legal system. Now, just here we have another of these fundamental texts, which are the result of Enlightenment, 18th century Enlightenment. We've already seen Montesquieu's Esprit des Lois, his idea of separation of powers, and how strong these ideas expressed by Montesquieu in the middle of the 18th century still are. We still believe that powers should be separated, and we still have this very profound idea that a state must have its powers, its main legislative power, administrative power, judicial power, they must be separated. Here we have another text which is equally important. It is the result of the same mood. The 18th century is full of enormous ideas from all points of view, and he has one of them that still influences us, and it is this fundamental text by Cesare Beccaria of Crimes and Punishments, 1764. It's a pretty small text. I suggest it's pretty short. It's written very well. Beccaria was a great writer. He was very good writer. The ideas, often he collected ideas from others and he put them in a very, very convincing and rest. So, and this is why Cesare Beccaria's text of Crimes and Punishments is a text that if you read it even today, 250 years later, you still find a whole lot of ideas which are still you interpret criminal law through Beccaria's eyes, through his text of 250 years ago. And we say these are not things of the past, these are things of the present. So this text is the basis of modern criminal law, not only in the European continent, but it has an enormous influence in the rest of the world, also in England and in the US. Just to point out that it has a sort of a world, in the Western legal tradition has had dissemination, of enormous dissemination. And so what we find, which I expressed in a very discursive manner, very strong rhetoric, a series of principles that we still apply when we look at criminal law today. So constantly, when we use Beccaria, whether we are in the US or we are in Italy, we are in Sweden or in Australia, we will use Beccaria to bring around some arguments that concern criminal law and procedure. And so I will go through some parts of this booklet. It's a pretty short booklet. It's about 120, 150 pages, not more than that. But it is really full of great ideas, which obviously you have to put them in the context of the 18th century, but they make us think of today's situation. We try to understand to what extent these principles are still valid 250 years later. Now, what I'll try to highlight sort of the main, let's see if I can move on. What are the, no, sorry, too far. Can you see the slides?
Yes.
Okay.
Yep.
So I just put out these principles with a few bullet points. Principle of legality. I return on this again because this is a central notion. It is one of the distinctive notions between sort of the European continent and sort of the Anglo-American model, which is very important. So I put the original, the quotes are original. This is an English translation of the Italian version. But it's also because I see we have, I saw there was Kid and there was Wood who are listening. So just tell them that there's an English translation, but there's also Chinese translation, Russian translation, all languages of Crimes and Punishments has been translated in all languages. It's such a fundamental text in not only from a legal point of view, but from a sort of history of our culture. So the laws only can determine the punishment of crimes, and the authority of making penal laws can only reside with the legislator. Now, if you think that this was said in the mid-18th century, when we didn't have really parliament, what we mean by parliament. I mean, Beccaria was writing in sort of 18th century Italy, which was, well, from a cultural point of view, it was very advanced, but from a political point of view, it was still pretty backwards. So there was really no parliament. The idea, anyhow, the idea is, because obviously Beccaria knew very well Montesquieu, Montesquieu knew very well Beccaria, their writings, so they are influenced one with the other. The idea that there's a legislator, that there's a legislative power that sets the law, who represents the whole society, united by the social compact, I would say, contract rather. No magistrate can, with justice, inflict on any member of the same society punishment that is not ordained by the laws. So the whole idea is that there must be a law, and the law, we shall see, is a written law, and progressively it is set by the legislator, at least in continental Europe. So this is the first point, the idea of legality. So there must be a law, and this law must be written and must be set. It can't be set by anybody. It is indicated the legislator. Hypothetically, the legislator could be the king, the sovereign, but well, Beccaria is moving this in an impersonal way, saying not the king himself, it is somebody that has the authority to represent the whole nation, and therefore the whole society. So this is what is principle of legality in Beccaria's text. Second point, principle of justiciability. That the fact that criminal law must be declared, must be enforced by the courts, by the judges. The sovereign can only make general laws to the members, so it's the sovereign, all right, let him make laws, but it belongs not to him to judge whether any individual has violated the social contract, for in this case there are two parties, one represented by a sovereign who insists upon the violation of the contract, and the other is the person accused who denies it. So the whole idea is that it is shows that there's a contrast between the public power that sustains, the king, the authority that sustains that a law has been violated and someone is accused of having violated the law, the accused person who says, no, I have not committed that crime, and therefore, and this is the conclusion, it is necessary then there should be a third person to decide this contest, that is to say, a judge. So the whole idea is the notion of the judge as a third party. There are two parties, there's the state, there's the sovereign, the state, the accused person, and the judge. If you go back to what we were studying when we were looking at Hobbes and the social contract, what is a social contract? That individuals agree to obey the king in exchange for a certain amount of services, which obviously the subjects will pay taxes and will be obedient, and the king must protect the individuals and will set the laws. But in this, if there's a dispute between the sovereign and the subject on whether this certain law has or has not been followed, has not been complied with, you need a third party, and the third party is a judge. So the idea that the judge is third party in a controversy. Now this is fundamental because obviously tradition is that the judge is someone who is there, who is controlled by the king, is designated by the king, depends on the king. Now this is something that we do not find in the English tradition. We see that progressively the courts become independent, but in historically, the idea is that the judge is some kind of public official which follows the rules of the sovereign. So the idea is that the controversy between the state, the sovereign, and the accused person must be decided by a third party, the judge. So this again is fundamental notion. For us it seems obvious, but we find that in many cases, not in criminal law, but in other cases, we ask ourselves, is this person who is deciding actually this institution, which is deciding the controversy, is it actually third, is it impartial, is it independent or not? So just to point out that these are basic notions that we must have in mind. Here we're looking at them from the point of view of criminal law, but we can see them, put them in any controversy when there is some kind of public law that has been allegedly violated, and the individual that claims that he or she has not violated that law. Third point, principle of written law was already cleared in Babylon, but you know, takes some time before these things are very clear. Principle of written law. Without written laws, no society will ever acquire a fixed form of government in which the power is vested in the whole. Why is this? Because it must be written, because one must know the law, knowledge of the law. So it must be known, and the only way to make a law known is by writing. Now, clearly, we could discuss this and see how the English common law has developed, but it was written, we do not find very strict provisions, just like we European continental lawyers like them, but it was written, and the Wood and Kidd, and if there are other English students that are following, know very well that the reports, court reports, started already in the 13th century. They were a very short summary of the decisions of the court were written down so everybody could know what the court had decided. So just to point out that the passing from oral rules to written rules is an important aspect in the development of criminal law. Then, principle of strict interpretation of criminal law. The whole idea, Beccaria says, well, criminal law cannot be interpreted according to the digestion of what the judge has at or has not at that day. In every criminal cause, the judge should reason syllogistically. The major should be the general law, so we have a general provision, the minor, the conformity of the action or its opposition to the laws, the conclusion, liberty, or punishment. So just to point out, sorry, there's a typo. So the whole idea is strict interpretation. So somehow to avoid free interpretation, the law has been set and the judge must give a very strict interpretation of this law. Further point, which is extremely important, principle of proportionality between crime and punishment. Now this is a sort of revolution in cultural revolution and ideological revolution in our Western traditions. Before, there was no relationship. It was some crimes were punished very severely, others were not punished at all, or were punished much less severely. There was no relationship between the nature of the crime and the kind of punishment that was inflicted. The use of legislation to prevent crimes should be more powerful in proportion. So you have to try to understand what is the crime, what are the interests that are protected. We should see this in a moment, and then we must see if that sanction is proportion. So this gives us an idea that criminal law is not simply the brutal force of the authority of the sovereign whose laws have been violated and therefore can apply any kind of sanction. No, this sanction must be proportionate. And so this is very important because this means a whole movement of criminal law towards a sort of a much more humane and enlightened view of the relationship between society and criminal sanctions. So just to point out, this again is for us, it seems obvious. In those times, it was not obvious at all, and these statements are somehow revolutionary for those times. And Beccaria adds, as they are destructive of public safety and happiness, and as the inducements to commit them are stronger, they ought to be a fixed proportion between crimes and punishments. So this relationship, the whole idea, and with this develops the whole idea of penology, the whole idea of how you graduate crimes. I mean, just think of the issue of juvenile delinquents. What kind, would you apply the same if you have a 12-year-old or 14-year-old, let's say a 14-year-old teenager that kills by somehow in a fit of rage, kills a friend or an enemy, a supposed enemy, should we apply the same kind of sanctions that we apply to someone who's grown up, is full of age, and can reason completely? So the whole idea is that they must be, you must try to understand the relationship that there is between who has committed the crime, the nature of the crime, and the sanction that you will apply. Then again, in this idea, and this is this foundation of modern criminal law, gradation of crimes. So you must try to sort of distinguish the crimes in accordance to what are the interests that have been violated. So some crimes are immediately destructive of society or its representatives. Just think treason. Somehow you want to overturn with violent methods the government. That's seen as extremely severely, obviously in the 18th century. Others attack the private security of the life, property, or honor of individuals. So the interest is a private interest. Life, very important, property or honor of an individual, but it is a private interest. The state wants to protect individuals, but these are private interests. And then actions that are contrary to the laws which relate to the general good of the community. We could think of someone who is driving under the influence of alcohol or drugs and is endangering people who are on the road. So just think of the idea is that of gradation of crimes and therefore gradation of sanctions. So the whole idea is if we look at the criminal text in the 18th century, they're totally confusing. Everything is mixed together. Instead here, the whole idea of Beccaria is that we start organizing crimes and therefore criminal law. When you will study criminal law, or those who already studied know that we sort of organize criminal law in accordance to what are the crimes, and the nature of the crimes, and what are the interests protected by those criminal laws. Then further, and this is basic theory of criminal law, individual and general preventive function of criminal law. So criminal law has dual function. One function is that to deter individuals from committing a crime. I don't steal because I know I will be brought to prison. So I know that if I commit a crime, I will be sanctioned, and therefore there's an individual deterrence. So this will serve me to deter me. But it is a general preventive function. So all society knows that there's a criminal law, there exists criminal law, and therefore the society itself will be an orderly and obedient society, because society as a whole knows that there are sanctions. And the punishment, therefore, is no other than to prevent the criminal from doing further injury to society and to prevent others from committing the like offense. So you want to prevent the individual who has committed a crime from committing another crime, but at the same time you want the whole society to know that crimes, if they're committed, will be sanctioned with some punishments which are fixed. Publicity of criminal trials. Now this seems to us obvious. If there's a trial, except for, very delicate trial, just think of rape, where there's the accused person who is the accused victim, who would be exposed to publicity, and therefore in that case, obviously the trial will be behind closed doors, or when we have juvenile delinquents. But the whole idea is that publicity, the trial should be public. Therefore, there is some kind of public control over what happens in the courts. Court is not something that is somehow, the trial is not something that must be hidden, can be hidden. It must be something that is in front of the public. Anybody can have access to the court and see how justice is administered. Presumption of innocence. Now this, again, to us it seems obvious. Here we have the expression, a very clear expression. Those times before, nobody really had said this so clearly as Beccaria said it. Presumption of innocence. No man can be judged a criminal until he be found guilty. In the eye of the law, every man is innocent whose crime has not been proved. So this is just to point out, this is a basic principle which we find fundamental in our legal system, in our Western legal systems, presumption of innocence. And here we have stated way back 2.5 centuries ago this idea that this presumption of innocence, not simply what the Latin expression, just let me get this, sorry, let's go, let me, write this down. So we have this nice Latin. In dubio pro reo. Now the idea in dubio pro reo is an idea, somehow is procedural. It has to do with the fact that if the evidence is not sufficient, well, in doubt, when in doubt, we will acquit the accused person. No, the whole idea is that we presume that the person is innocent, and therefore you must, public prosecutor, the state that brings the accusation must demonstrate that that person is not innocent. We will return to that when we look at the Anglo-American model, particularly the US model. But this idea of presumption of innocence is something that we feel is essential in our criminal law system. You cannot be presumed guilty but you are presumed innocent, and therefore you must the state that brings this accusation must somehow overcome this presumption, and with a certain strength. And therefore, prohibition of torture. Torture was very common well into the 18th century and even in the 19th century, because torture is a punishment which is inflicted on a person who is innocent, who is presumed innocent. And what are you trying to do? You're trying to force that person before the trial to confess a crime through violence. So this is obviously torture is against the whole idea of a presumption of innocence. But just to show you that the torture is not made so much on a humanitarian reason. Obviously, it is clearly torture was real torture, was horrendous ordeal imposed on the tortured person. Here, the whole idea is very logical. You cannot torture someone who is innocent. That person is innocent. So until the trial comes and until evidence is brought against the individual, there can be no, you cannot torture. And this obvious consequence is a further consequence, suppression of the death penalty. This is, Beccaria is the first and the main proposer of suppression of death penalty. Is it not absurd that the laws which detest and punish homicide should, in order to prevent murder, publicly commit murder themselves? So this is rhetoric, but we see that after 2.5 centuries, we see that this idea of Beccaria is followed in most, not all, most of the Western legal tradition. Country exception is the US, but in certain states, not all the states, 50 states of the United States of America. So just let me see, go on to. Now, just to show you what is the influence. Beccaria's thought is constantly used in anything that the criminal law, from 1764 onwards, there's no criminal legislation that does not somehow use ideas that Beccaria expressed in a very clear fashion. We find he influenced the first modern criminal penal code of the Grand Duchy of Tuscany, of the Grand Duke Leopold. Leopold was the husband of Mary Therese of Austria, and so that makes it very clear. The Enlightenment subsequently also in Austrian Empire, they have similar codes, but 1786, we see that this penal code of the Grand Duchy of Tuscany, and if you read it, you can see very well that this is a code which is somehow turning Beccaria's book into a list of provisions. Those principles that I have set out in those bullet points are somehow put into law and transformed into specific provisions. Then if we look, and if you go back, you have the text that we analyze when we're looking at fundamental rights. If we look at the French Declarations of Rights of Man and Citizen, 1789, that is 3 years after the Tuscan Penal Code, Article 7, no person shall be accused, arrested, or imprisoned except in the cases and according to the forms prescribed by law. So here we see Beccaria's ideas put into a legal text, and just think of this, the whole idea is that in France, the law is made by Parliament. That is, the will of the nation is expressed by Parliament, and Parliament sets criminal laws. So just to point out that this is, it becomes from an idea at that time was a sovereign. No, now it is Parliament. It is a legislative body that sets criminal law. Article 8, law shall provide for such punishments only as are strictly and obviously necessary, idea of proportion. And no one shall suffer punishment except it be legally inflicted in virtue of a law passed and promulgated before the commission of the offense. So here we have another principle. We should see it in a moment of when we like to use these Latin formulas. Here you see the law, proportion, written law, law must be before the commission of must be promulgated before the commission of the crime. So you cannot, criminal law cannot be retroactive. And Article 9 of the French Declaration of Rights of Man and Citizen, as all persons are held innocent, presumption of innocence, until they shall have been declared guilty, if arrest shall be deemed indispensable, all harshness not essential to the securing of the prisoner's person shall be severely repressed by law. That is the whole idea that is behind Beccaria's prohibition of torture. So just to point out, I will just move and stop here. Just put out, I will just give you this focus on this sorry. What is this? No, I don't see this. Well, I have. Okay, let's put it nice here. Lex scripta, stricta, previa, etc. Well, this is Latin expression. I repeat, we lawyers, we love Latin expressions, whether we're here, across the channel, across the Atlantic, we love Latin. Scripta, written, stricta, strict, therefore it must be very clear. Previa, that means it must be beforehand. It cannot be retroactive. I cannot set out laws for something establishing something that was committed in the past is a crime. If it was not a crime in the past, it is not, cannot be retroactively become a crime. And Certa, that means it must be certain. It must be very clear that it is clearly stated, and there can be no doubt, ambiguity on the text. So just to point out that these are the great influences of Beccaria's thought, and which we find already enacted in the 1789 declaration, French declaration. Then we will see subsequently in other modern texts, which then are somehow follow throughout the centuries. We find them, I don't say copied, but the main ideas are there in, at least when we look at penal codes. So this is what I wanted to present to you today. Are there any questions on this part? Then we will move on to, well, tomorrow we will move on to somehow comparing this model to other models. So there are questions.
Professore, posso fare una domanda in italiano che però non c'entra nulla con il materiale che ha spiegato oggi?
Well, why did you say it in English? I think it's good for you. Sorry, because it's useful also. As I see that there's kid, there's wood, and the other. And although obviously although they've been few weeks in Italy, they know very well Italian. But I would suggest you present your.
Okay. We have a problem, I think, with our faculties, because I think even my colleague and I, many of us don't have the first certificate, and we were going to get it, I think, in May. But the class stopped the exams, and they are waiting. They are waiting for new to establish new dates of the exam.
No, don't worry. We will surely solve this out. Clearly, this is an exceptional situation, and when it comes to exceptional situation, we are not going to apply rules that were sought for an ordinary system. So I don't be concerned. They will be the solution. And clearly, we will not we will not apply rules that sort of in a stupid way. At least this is my point of view, but it is the point of view of everybody at Roma Tre. So don't be concerned. We will see clearly. There must be. You must have some kind of certification, language certification, but we shall see that this is done in an appropriate way for the circumstances, taking into account the circumstances. You may have seen that, for example, high schools, the final exam this year will be done in a significantly different way.
Yeah, my best friend is so happy about that.
So just to point out that, please, we will find a solution. This is a problem. We will find, I hope, an intelligent solution, but it is clearly my interest, as I'm the only teacher in the global legal studies class, that I must ask your English proficiency. So it will be my task to ensure that everything goes properly and that there are no sort of not unreasonable rules applied in this exceptional circumstances.
So I don't have to look for some sites that are trying to have those telematic exams.
Oh, I think I would go on the Roma Tre. It is Roma Tre that has to provide this kind of certification, and it will find a way of just as I mean, we are doing video lessons. As a matter of fact, I've been director of the class for 6 years in the past. When I was there, we started moving most classes. We started moving in blended classes from in-presence classes to blended classes, and then completely online classes. So I trust that Cloud will be able to cope also with this situation. I've taken note of your concern, and I will obviously ask for a reply from the sort of university academic authorities, offices which are in charge of giving these certifications.
Thank you. Thank you.
Any more questions on this part devoted to Cesare Beccaria? No more questions? Well, if there are no more questions, I'll just ask you, please, just leave your name. If you haven't put it already on the chat, just because I haven't been able to, because I took note of the first 37, 38 names and not about 12 others that arrived. If you can just put your name. The first people are obviously the first 37 till 5:05. Those that logged in after 5:05, if they can just put their name in, and so I just know who is there. And we will reconvene tomorrow afternoon, 4 o'clock, and I will try to highlight the differences between this continental European system and the Anglo-American system, mostly American system, and show what are the differences, which are important, but how at the end of the day we must put these which are apparent differences, we must put them together and have a global view of what we mean by criminal law in the 21st century. But we will discuss this tomorrow, and see you. Good afternoon to everybody, and we meet together tomorrow.